Hello and welcome to the MCQ lecture series. In today's class, we are going to look at some of the important multiple choice questions with respect to Financial System 2, which is the economics general paper for SYBA. I've already started with some of the important MCQs regarding chapter 4 from semester 2, which is the last chapter. So you can find the links in the description below. In today's class, I'll talk about the Insolvency and Bankruptcy Code Bill. In my previous lecture as well, I have covered some of the introductory topics related to Insolvency and Bankruptcy Code. In this class as well, we are going to continue with the same. So let's get started. The first question is in relation to the objectives of Insolvency and Bankruptcy Code. The question is, which of the following denotes the objectives of Insolvency and Bankruptcy Code in India? So here specifically objectives of Insolvency and Bankruptcy Code, and the underlying options are A, to consolidate and amend all the existing insolvency laws in India. Second is to simplify and fast track the insolvency and bankruptcy proceedings in India. The third is to help and revive stressed companies in a time bound manner. And the last is all of the above. That means consolidate and amend all the existing laws in India related to insolvency. Second is to simplify and fast track the resolution mechanism and proceedings related to insolvency and bankruptcy in India. Third is to help and revive stressed companies in a time bound manner. So here option D, all of the above, is the correct answer with respect to this question. So option D, all of the above, is the correct answer. Let us now move to the next one. The next one is also in relation to objectives, and the question is the objectives of Insolvency and Bankruptcy Code are dash. So here again the objectives, let us look at the first one: to promote entrepreneurship. Second is increase credit supply in economy. Third is to work on a new and timely recovery procedure for banks and financial institutions, and last is all of the above. So here again, which are the objectives of Insolvency and Bankruptcy Code? All of these are the objectives. That means option D is the correct answer. Here the options are A, to promote entrepreneurship, increase credit supply in economy, and to work on a new and timely recovery procedure for banks and financial institutions. So in these two questions, we have seen in all 6 important objectives of Insolvency and Bankruptcy Code 2016. Let us recollect that. The first is to consolidate and amend all the laws, existing laws relating to insolvency in India. Second is to simplify and fast track the insolvency and bankruptcy proceedings. The third is to help and revive stressed companies in a time bound manner. Fourth is to promote entrepreneurship. Fifth is to increase the credit supply in an economy. And sixth is to work on a new and timely recovery procedure for banks and financial institutions. So these are 6 important objectives of Insolvency and Bankruptcy Code. I hope the questions are pretty much clear. Let us now move to the next one. Very important question, might reflect in your paper. The key components of Insolvency and Bankruptcy Code 2016 are what? The key components here specifically, what are the key components of IBC 2016? So let us look at the options. First is adjudicating authority, usually written as AA. The second is Committee of Creditors, usually written as COC. Then we have insolvency professionals, and last is all of the above. So here the key components of Insolvency and Bankruptcy Code 2016 are denoted by all these 3 options, that is A, B and C, and hence option D, all of the above, is the correct answer. That means the key components of Insolvency and Bankruptcy Code 2016 are adjudicating authorities, committees of creditor, and also the insolvency professionals. So here option D is the correct answer. I hope the question is clear. Let us now move to the next one. The special bodies constituted for adjudicating resolutions of matters relating to insolvency and bankruptcy are what? What were the special bodies that were constituted for adjudicating or making decisions upon or providing resolution mechanism for matters relating to insolvency and bankruptcy in India? What are the names of these bodies? Whether it is A, National Company Law Tribunals and Debt Recovery Tribunals, B, High Courts and Supreme Court, C, Parliament and State Legislatures, and D, none of the above. So here the question is very important, might reflect in your paper. The special bodies constituted for adjudicating resolution of matters relating to insolvency and bankruptcy in India are nothing but NCLT and DRT, that is National Company Law Tribunals and Debt Recovery Tribunals. So here option A, NCLT and DRT, is the correct answer with respect to this question. Very important questions, question number 3 and 4. Let us now move to the next one. The next is the National Company Law Tribunal appeals lies to the NCLAT, that is National Company Law Appellate Tribunal, and after the decisions of NCLAT, that is National Company Law Appellate Tribunal, the party can approach which institution, and the underlying options are A. High Courts, B. Supreme Courts, C. Sessions Court, and D. None of the above. So you have to understand the process. There is NCLT, that is National Company Law Tribunal. The appeals which are made to NCLT are heard by NCLAT, and then the decisions are made. So what happens is, an aggrieved party cannot approach NCLAT, that is National Company Law Appellate Tribunal. You have to first approach NCLT, and then this will direct you to NCLAT. So here what is happening is, NCLT, which is National Company Law Tribunal, has the original jurisdictions, and here the NCLAT, that is National Company Law Appellate Tribunal, has the appellate jurisdictions. Okay, appellate jurisdictions. Now what is happening is, the question is asking, the appeals which are raised at NCLT are heard by NCLAT, that is the appeals which come to National Company Law Tribunal, as you cannot approach the NCLAT directly, these will be heard by the National Company Law Appellate Tribunals. And if you are not happy with the decisions made by National Company Law Appellate Tribunals, you can approach which of these institutions? The underlying options are A. High Courts, B. Supreme Court, C. Sessions Court, and D. None of the above. So here, if at all you are not happy with the decisions made by the National Company Law Appellate Tribunals, the aggrieved party can move Supreme Court, and therefore option B, Supreme Court, is the correct answer to this particular question. Now the next question is but obvious, who can approach NCLT? And the next question is in relation to that. Let us look at it. The National Company Law Tribunal, or NCLT, is for dash, and the underlying options are, it is for A. companies and limited liability partnership firms, B. unlimited liability partnerships and sole proprietors, C. banking companies, and D. all of the above. So here the correct answer is, all the companies and limited liability partnership firms are directed towards NCLT, and therefore option A is the correct answer. That means NCLT is for companies and limited liability partnership firms. National Company Law Tribunal, National Company Law Tribunal, you can approach companies and limited liability partnership firms can approach NCLT. The procedure I have told you how to go about it. Okay, so I hope this is clear. Now there is another specialized body here. We have seen that the special bodies constituted for adjudicating resolution of matters relating to insolvency and bankruptcy are National Company Law Tribunal and Debt Recovery Tribunal. So let us look at the next question, which is talking about Debt Recovery Tribunal. So here the Debt Recovery Tribunal, DRT, is for dash. Now who can approach the Debt Recovery Tribunal? Let us look at the underlying options. A. companies and limited liability partnership firms, B is unlimited liability partnerships and sole proprietors, C is financial intermediaries, and D is all of the above. So we can see that this option is there in this question, and that was the answer for that question. That means companies and limited liability partnership firms can approach NCLT, okay, National Company Law Tribunals, but unlimited liability partnerships and sole proprietors are to approach DRT, that is Debt Recovery Tribunal. Okay, so here the correct answer is option B, Debt Recovery Tribunal. Okay, I hope both these questions are pretty much clear, and also the distinction between these two specialized bodies as we have seen, which were constituted for dispute resolution mechanism. I hope the questions are clear. Now in similar fashion, we have seen NCLT and NCLAT, that is National Company Law Tribunal and National Company Law Appellate Tribunals. So here in similar fashion, there is DRT and the DRAT, that is Debt Recovery Tribunals and Debt Recovery Appellate Tribunals. A similar sort of procedure. If when or to whom I will go if at all I am not happy with the decisions made by Debt Recovery Appellate Tribunal, whether it is A. Sessions Court, B. High Court, C. Supreme Court, or D. Parliament. Again here, if at all I am not happy with the decisions made by DRAT, that is Debt Recovery Appellate Tribunal, I will move Supreme Court. So here again option C, Supreme Court, is the correct answer. I hope the questions with respect to the objectives of Insolvency and Bankruptcy Code are pretty much clear, and also the key components of IBC, the adjudicating authority, the committee of creditors, insolvency professionals, and also questions in association with these special bodies constituted for the adjudicating resolution of matters relating to insolvency and bankruptcy, that is NCLT, that is National Company Law Tribunals, and DRT, that is Debt Recovery Tribunals, are pretty much clear. In the next class as well, we are going to look at some of the important multiple choice questions with respect to chapter 4. So please stay tuned for more. Thank you.